Appeals, Division 1, is now in session.
Thank you. Please be seated. This is the time set for oral argument in the case of HERREN versus ARMENTA et al., our civil number 18-0381. Each side will have 20 minutes within which to present their argument here this morning. Appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of your time in that regard. We have read the briefs, we've been through the record, we've conferenced the case, so we're familiar with the underlying facts and procedural history of the cases. So please keep that in mind as you make your arguments here today. We are recording the proceedings, both by audio and video. So as you approach the podium, please identify yourself and your clients for us. And with that, Mr. Abney, you may proceed.
May it please the Court, my name is David Abney, representing Robin HERREN, the plaintiff appellant. I'd like to reserve about an hour for rebuttal, but I guess 5 minutes will do. I thought I'd never say the phrase profit a prendre in any courtroom. In fact, I don't remember hearing it since I left college. There was a Professor Cosgrove there who did common law studies and common law courses in the history. And I think I ran across it there, but I haven't run across it since. It's not something that you normally run into. I hope to talk about the profit a prendre issue and about retired Arizona Supreme Court Chief Justice Lackett's causation opinion, which I believe that he did give. There seem to me to be 7 documents that are of great importance. You kick off in the importance, of course, with the first one is the deed of July 1st, 1949 from Santa Fe to David Morgan. And in that deed, Santa Fe conveyed a fair amount of land, including what would be the 40-acre parcel that's at issue here, and reserved to itself the minerals, but not just the minerals, reserved the minerals with the right to prospect, mine, and remove the minerals. And by doing that, Santa Fe created by reservation a mineral estate, the mineral ownership, just the minerals, and a profit a prendre, which is this unique common law right to go onto the land of another person and to sever from it all kinds of substances. It developed from the English common law of the commons, where there were certain rights given to people to go to cut peat for fuel, or to fish, or to cut timber, or to get brush, or whatever they needed. And gradually common law solidified a bit, and you had the profit a prendre that developed as a very strong, clear right in the common law.
But don't you have to own the minerals that are going to be removed?
No, not for a profit a prendre. In fact, for a profit a prendre, you don't own the minerals at all until you have gone onto the land and actually severed them. Once you have,
if I give Judge Johnson a deed granting her all of the minerals, the rights to all of the minerals in the property, and I guess this gets to the Ford deed. What is it that I've reserved when I give her all of the rights to the minerals in the property? What can I give to someone else through a profit a prendre? They can come and take the minerals that I've told her she owns? If you
just gave her the minerals, she would have an implied right to make use of those minerals as long as she didn't interfere with the land itself. If all you gave her was the minerals, she would have an implied right to come onto the land. It's a lot like a profit a prendre. The difference is with a profit a prendre is you sever the minerals themselves from the right to go onto the land and take the minerals out. There's no ownership of the minerals under a profit a prendre until you've gone onto the land and severed them from the land, and at that point you own the minerals. At that point it becomes your personal property. But a profit a prendre is different from simply saying you own the minerals. So you have the right to go onto the land of another person and sever the minerals.
So I'm curious about how all this relates to the malpractice case.
Well, here's how it relates. When push came to shove in the legal malpractice case, never before had these attorneys said, well, you don't actually own any rights to the sand and gravel. Now, all of a sudden, well, by golly, you don't own any rights to sand and gravel.
So it wouldn't have mattered.
And the matter is that her damages plummet.
What? Okay. Well, and we'll ask them what the damages. They think the damages would have remained. But I don't read either of your experts' opinions to touch on this legal issue.
No, he doesn't. He's other than the fact that he's saying they didn't do research as to what her rights were. But what he's saying there is what her rights were in the dispute between her and Tonto Supply, which was the company that she had invited on to exploit the minerals and to set up the plant, which they did set up the plant and to begin the extraction and the severance, extraction, and removal of the sand and gravel.
So if we decide to rule on the legal issue of the profit and conclude that there was no profit, what does that do to the malpractice case?
It cuts out a major portion of the damages, but it still leaves damages for getting embroiled in a lawsuit that Chief Justice Laggett says she should not have gotten embroiled in.
Because he says the lawyer should have said, time out, let's go back to square one. Do you really have anything here?
Well, time out, let's go to square one in the dispute between her and Tonto Supply and say, well, what is actually the dispute here? Is there some sort of plan that you need to give to Tonto Supply? Well, maybe you should give it to them. Is there a dispute about how the profits in the regular sense are going to be paid out from the extraction of the sand and gravel? We'll resolve that. Don't go push Tonto Supply so hard. Don't threaten them with criminal charges. Don't threaten them with legal action, but work out this dispute so you can go forward and actually make some money off this operation.
But can you just say work it out? I mean, don't you need to have a theory? I don't see in that affidavit something that says this is what should have been done, and if this had been done, this is how the client would have responded, and with say an affidavit from the client saying, yes, if they had told me this, I would have dropped the lawsuit or I would have done something different. All I see in the affidavit is they didn't do some things, and without connecting it to, well, what should they have done?
Well, what they should have done, and I thought Justice Lackett laid it out fairly well, they should have investigated thoroughly and not pushed her into the lawsuit. And if they had done that, there would not have been
Let's start with
litigation.
you agree that the affidavit doesn't say anything about the lawyers should have investigated whether there was a profit a prendre.
No, the profit a prendre does not figure into that, at that part.
What about the legal right
For the dispute,
to the mineral?
Yeah,
to the
no,
minerals?
that's not really figuring into the dispute between Tonto Supply and HERREN. The dispute between them was this environmental plan, development plan, and the profits, how you're going to extract, licenses, all kinds of things like that were simmering between them. And it turned out that if these lawyers had investigated properly, they would not have pulled Tonto Supply's trigger. By threatening with legal action and then with criminal charges, Tonto Supply reacted, forcefully and vigorously and successfully, and said, "Well, hold on, we're on the right side here. You're on the wrong side." And Justice Slack was saying, "Well, they should have investigated enough to know that she was in a weak, wrong position in this thing, and she wouldn't have gotten embroiled in this lawsuit, which cost her attorney's fees, major damages. The whole operation fell apart. It was a disaster for her, and it was caused by the lawyers who committed the malpractice."
So the advice that your expert says should have been given is, let's try to settle this case reasonably without turning it into a war.
Right.
Not, do you really have the right to mine the minerals?
Correct.
Okay.
Absolutely. And that just came out later. Now, my position is, and I didn't mean to be facetious, and I thought when I was reading my opening brief, maybe you might have thought I was being facetious, and I wasn't trying to be facetious. But it seemed to me that if they're saying now she didn't have any mineral rights, well, they should have said it then. They should have looked at this themselves and said, well, hold on. I'd be embarrassed to come along later and say, I gave you such crummy advice that you actually, the thing that you were relying on, these mineral rights, you didn't actually have.
But that's a tough argument to make now, given that you're pursuing an argument that she does in fact have.
Well, she does. I firmly believe that she
So
has
even if the
rights.
attorneys had said you shouldn't pursue this because you don't own it, that would not be a basis for malpractice. If you can't say she should have relied on that, but
it's one or the other. I think I've got them coming and going on this, and I'm not trying to go back into facetious land. I really do think that there's a problem here. They either gave her bad advice about what she owned or didn't own, they gave her no advice, and now they're saying they're wrong either way you look at it. They should have known that she didn't have it, or they should have given her different advice at the beginning. They just mess this up every way you can.
But in any event, that wasn't an issue in the underlying lawsuit.
No, the profit of prodigy thing, I don't think anybody really knew what they were dealing with. You go from 1949, where it looks like Santa Fe is setting up the profit of prodigy, go forward 54 years to 2003, Santa Fe is saying, oh, okay, we're going to give you right title interest to the minerals. You agree that in your operations that you are going to abide by all the regulations, including reclamation. So that's an unusual thing to see in a deed.
Of course, it said minerals, if any.
If that's the if anything was what I was working towards. It's like Santa Fe. I guess everybody retired or died who knew anything about profit of prodigies at this Santa Fe office, and they knew they had something. They knew they had rights. They weren't exactly clear. They were fuzzy about what they were. And I think that everybody in the lawsuit was a bit fuzzy going into this and moving forward as to exactly what they had.
Well, I thought you said that was not part of the underlying lawsuit. There's just an assumption that your client had some had the mineral rights. There's not a dispute.
She firmly believed, that based upon the deed, the 2003 deed from Santa Fe, that she had the right to remove the sand and gravel down to a level of 100 feet from the surface on the 40-acre parcel.
Could you go to the deed to Ford Motor Company? And your argument is that they only conveyed part of the mineral rights to Ford. What are you saying? What part did they grant? What part did they not grant?
The minerals. They gave to Ford the minerals. They did not give to Ford a profit of prodigy, which would be a right to go on, a separate right to go on and sever the minerals and turn them into personal property and remove them. They simply gave them the minerals. It would be as if Santa Fe had just said, okay, to HERREN, and that's what happened. Santa Fe owned the minerals, and it says to HERREN, okay, we're not giving you the minerals exclusively. What we're giving you is a profit of prodigy. We're giving you a right to come in and sever the minerals, in this case, sand and gravel, down to 100 feet. It's a fine distinction. It's something that we struggle with because we're not used to this common law concept, which I think lawyers in the mid-20th century would have been a lot closer to this and based upon this deed in 49, they seem to have a much clearer understanding of what they're doing. These kind of fine common law distinctions matter. It's money in the bank. Because Santa Fe is holding on to the profit when it gets away the minerals. It still has its profit of prodigy. It can go onto that land itself.
So what can Ford Motor Company do when all of the minerals have been granted? Can Ford take whatever minerals they want out of there?
As long as they don't interfere with the remaining right that Santa Fe has in relation to the minerals, which is its profit of prodigy, which it did not give.
How would they not interfere with it if they decide to take all of the minerals out of the property? We own it. I look at that deed. I own all the minerals whatsoever. I'm going to mine them.
If Santa Fe were taking out sand and gravel to use in its road operations for ballast and for other purposes, and it had an operation going, and Ford comes on and starts taking sand and gravel, that's fine. They can have both. They can have joint operations, one place and another place, same property, as long as they don't interfere with each other while they're doing it. It's when there's an interference, they'd wind up in court. But you can have removal operations going on at the same time at the same property. That's fine. The common law says that's okay. If you own those minerals, you have a general right to extract them. If you own a profit of prodigy, you have a right to come onto the property, remove the minerals, becomes your personal property, and away you go. It's an interesting concept. It's just not one we're really comfortable or familiar with. We tend to leap to, if you buy the minerals, what else do you need? But the common law says you can have this profit of prodigy.
I, for one, enjoyed that section of the brief. It took me back many, many years to property. But new topic. As I understand the opinion, it's that the lawyers were negligent by not informing their client that this was a loser case, it's not wise to pursue it. We need to resolve it.
In broad strokes, yes.
What case authority have you got for the proposition that that theory can work in a legal malpractice case? The cases seem to say you need to prove the case within a case, which is you would have won. That's the context of all the other cases, as I understand it.
That's when there's actual litigation, when you actually get involved in the lawsuit itself.
Right, and that's-
But you can have malpractice, and I cited the cases and Dobbs on torts about recoverable damages on page 64 of the opening brief is a good source too. But I cited cases where if you get a client involved in litigation and the client should not have been in the litigation, then you are responsible as a lawyer for the damages that you have caused by your negligent advice.
Well,
Is there anything in the record, Mr. Abney, that indicates that had the client been given that advice, that she would have taken it? That she
No.
would have agreed to enter into negotiations to settle the case immediately? Or
Not
dismiss it?
Not specifically.
Don't
but
you need that?
No, because what you're talking about is foreseeability, and that's a jury issue. That's a pure jury issue. You can't get around that one. You've got the duty not to give crummy advice to your client, get them embroiled in litigation they shouldn't be embroiled in, and then once you say, okay, there's been a breach of that duty, what happens next? Is a proximate cause, damages, and its foreseeability comes in at that point. And that's a fact question for the jury to resolve. We never got that far because the judge said, well, he didn't give a causation opinion at all. But if you go through, it's a bit, Justice Lack has a clean, interesting, strong writing style. He goes through about 7 pages of his original declaration, and he says, well, this is what they did wrong. They breached the standard of care here, 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 and here. And then when you get around page 7 or so, and in conclusion, let me see what he said. And in conclusion,
Most of the things he's going to are not, they contributed to her losing the lawsuit.
well, part of it did, sure, but part of it was the negligent investigation, getting her involved in this mess when she shouldn't have been involved in this mess.
But she kind of started the process herself. So how,
Well,
don't you need her saying, yeah, I would have withdrawn immediately? It's hard to say. You can say that if the attorney said X, Y, or Z, but if she's just adamant that she's right and she's going to pursue it, don't you need her to say, yeah, I would have recognized it and I would have dropped the litigation?
To prove the case at trial, you would need to do that. But here, the only thing the judge was dealing with was causation. I don't see any causation opinion here from Justice Lackett, but he goes through carefully everything that went bad, including the bad investigation, the bad advice, and he says that what the attorneys did damaged her and caused or contributed to the final judgment. There wouldn't have been a final judgment.
But that goes to the merits of, that's the case within the case.
No,
So-
it also goes with what should there have been a case at all? Because the bad advice caused or contributed to the final judgment in 2 senses. One, well, the bad advice and the bad conduct. The bad advice and the bad advice led to the lawsuit to begin with.
We have the findings on this court in the previous case, in the case within the case said
Yes.
that didn't matter. There was enough in the record. It wasn't the failure to respond that she still would have lost this case within the case. Am I misreading the previous decision?
I believe you are. That's one of my appeals in a very painful memory, but I did the best I could with it. But part of it was the request to admission being deemed admitted, but mostly it was the way they handled the summary judgment matters. And that was really what I believe this court was talking about, that because of the way the summary judgment was handled, there was no hope. It wasn't just the request for admission. So you take it all together, then the lawsuit was a disaster. But Justice Lackett is a twofold point. He tried in his supplemental declaration. He tried even harder to make it clear. It's two problems here. One is the bad advice that got her involved in the litigation. If they had given her the proper advice, it wouldn't have happened. And then the other thing is the way they mishandled the litigation itself, which was just horrendous. I'd like to reserve my time, if I may.
All right, thank you.
Thank you.
May it please the court, my name is Tony Vitagliano. I represent appellee Chris Armenta. Appellees will split their 20 minutes. I'll take 10 minutes and reserve 10 for Holden's counsel.
We're going to talk about specific subject matters.
I'm sorry?
Are you going to talk, have you divided up the subject
We,
matters?
we've not,
Okay.
for a number of reasons. Plaintiff makes arguments in both briefs, so we have to both attack some of them. I think the profit appendage is a Trojan horse, but we'll leave that for the end.
Why do you think it's a
Causation,
Trojan horse? How does that relate to this case?
I don't think it relates here at all, because if they can't prove causation, it's irrelevant for their damages. But the deeds, Judge Conti's correct, the deeds are clear. There's no profit appendage reserved in the first deed. It's a given of all the minerals. For it to have been a profit appendage, as our brief clearly sets forth, it's got to be clear, distinct language of reserving, such as some cases say we reserve the right to go on and take this timber from these trees, et cetera. Santa Fe never does that. There's no profit appendage involved. That was only raised after the court ruled against them, and that was her way to try and get around it. Just like the pre-litigation argument was only raised to try and get around that claim. But if I can get to that, causation, I guess I don't need to go through Glaze. You all know what Glaze requires as far as proving malpractice in the litigation attorney case. Got to prove that. But for the attorney's actions, they would have prevailed.
Well, what Mr. Abney is saying is that case doesn't apply because this is a pre-litigation case.
Yeah, well, Mr. Counsel's wrong. That case does apply.
Is there a case that says that?
Yeah, and I'll go through for you right now why it does. So recognizing she couldn't satisfy Glaze, she came up with that. And she argues that this allegation that Armenta's actions in prepping for the case shouldn't fall under Glaze are wrong. It's contrary to Arizona law. It's contrary to the facts and her complaint. Under Arizona law, all appellees' representation of HERREN during the Tonto matter, whether before or after the filing, is in the course of litigation subject to Glaze. That's Glaze 26 at paragraph 1, 32 at paragraph 24.
If you're consulted before litigation starts and you advise the client to go into litigation, that's...
Yeah, if it's part of the litigation, they call her in, the engagement says it's for the dispute, they call her in to talk about the dispute, it's all related to the litigation. As Glaze says...
You're saying there's no recourse if somebody says you've got a really good lawsuit and you should spend a lot of money on that, as opposed to just looking at it and saying there's absolutely nothing here, you're going to waste any money you put into this is not going to be...
Either way, if you're saying that, I didn't follow you, Your Honor, if you're saying that someone says you do have a case when you really don't, or when someone says you don't have a case when you do?
The second, okay? If that's the argument now, that the lawyer, I recognize that I have no case, and the lawyer should have told me that, and it would have saved me a lot of money.
Okay, so first off, they don't recognize they have any case. This was a contract interpretation case. They argued that they did not have to pay the plan.
When you say they, who are you speaking of?
I'm sorry, HERREN. HERREN argued, this is in the case below. HERREN argues in that case below that she doesn't have to pay the plan, environmental plan, because it's only due to the differences that Tonto did, the diverting from the plan that Tonto did, and therefore Tonto is responsible for it. Tonto says you're responsible for it because our agreement says you have to get all the permits. So now this is a clear contract interpretation, matter of law case. As we know, as we experience every day, this can go either way. There's never a loser, a pure loser one way or the other. It just depends on the particular facts and the interpretation. What does the court view as a matter of law would override? The fact that Tonto didn't do what they were supposed to do, and that brings in the need for the permit, or the fact that the agreement says, I'm supposed to pay for permits, but of course that's only if you do what you're supposed to do. So they never had a sure loser. They allege it now because it lost. I mean, they appealed it. They lost on the appeal. The court, as Judge Conchi says, the court said, hey, look, all that other stuff aside, there's evidence supporting that they win on summary judgment. So it was ruled on the merits and not on any procedural issues of that. Claims that Glaze doesn't apply, Glaze and Olafson and all the cases cited in our brief says that's not the case. if what I'm giving you, the counseling I'm giving you, relates to the litigation, then if you could win the litigation, that's what determines whether you have malpractice. Glaze defines litigation context malpractice to include allegations of malpractice occurring any time during the course of the dispute, representation leading up to and during the litigation, regardless if it's before or after, because the idea is if it's because of that, if you could then turn out and win, then you don't have any harm. And so the
Necessarily that you would have to win. I mean, couldn't you say that there would have been an opportunity, there would have been some negotiations that would have just resulted in a settlement, and that would have been the best result if the attorneys had just been on the ball and responded.
Well,
that's what would have happened here.
Your Honor, the attorneys on that point, they were on the ball. The amended complaint, it's in our brief. The amended complaint, I can't recall the paragraph right now, says that the parties tried to settle it and they couldn't. So any claim.
But isn't it harder to settle if you
Pardon?
missed? Isn't it harder to settle if you haven't responded? I mean,
No, this was before.
This is before.
This
the
was
failing to
before.
respond.
This is when they came in. They attempted early on, and it's in the amended complaint, and it's cited in my brief. They went in there and they tried to settle, and they could not. So any claim that they lost, they could have settled, any of these claims by the expert are completely speculative and have no bearing in the.
Well, I'm not quite sure. I mean, I get that that Glaze talks about conduct expansively in litigation, but it seems like to not acknowledge that there can be malpractice in the failure to tell a client, get out, it means that in a loser case, the lawyer has no duty whatsoever. Because the case is a loser regardless of what the lawyer says, answer requests for admissions or not.
Sure, Your Honor. But as you know, every case is a winner and a loser. It just depends on how the chips fall with the jury or whatever. This case, there's nothing that made this case on its face a loser. The plaintiff comes in and says, I own all these rights. And the issue of the rights came up in that case. In that case at some point.
How and where did it come up?
The Tontos, halfway through the case, they found something out and they filed a stay. They're telling the court, and it's in my brief, they filed a stay saying, hey, I don't know if you have jurisdiction over this because I don't know if they have the rights. The court decided they'd go through with it anyways, and the plaintiff, HERREN, has always said, no, I have those rights. Today she says she has those rights before this court, regardless what you want to call them. So that issue, there was no way that issue at that time would stop litigation because HERREN at that time still said it. She still alleges she owns them. The Bureau of Land Management ruled she didn't. She then appealed, and they said, okay, you bring evidence and we'll see. She's yet to bring any evidence.
Was this before the trial?
No, this was
That's
afterwards.
So you're
yeah.
saying there is, though, your brief highlights when it was raised for the
Yes.
first time, and it was before the end of the underlying litigation in this case.
The issue was raised during the underlying litigation by Tonto saying, hey, wait a minute, we're not sure you own this. Now, that was never an issue. That was never a reason we were brought in. And so there was no reason to go, as you know, you're an attorney. If your client tells you a fact, some facts you look into. If they tell you, I own this property, and that's not an underlying issue in the dispute, you're not going to spin your wheels and spend all of their money determining whether they truly own the property. That's the case here. She says, I own this stuff. We come in, we say, okay, you do. And then later someone raises an issue, and it appears she doesn't. And sure enough, I don't believe she does. So as far as Glaze goes, the cases that he mentions in his brief, Tenon, Toy, Commercial Union, Tuller, Best Choice, Koloff, all of them deal with litigation in a transactional setting. Because there, it's, you don't have the second bite of the apple of seeing whether I could win. Same reason why the mere fact that he alleges, well, this isn't a medical malpractice case where there's a loss of chance. That's not been claimed, and it doesn't apply here. because it's not like loss of chance only applies where you come in, you interrupt something. Here they're claiming it's due to our negligence that they're losing the money. So I'm trying to save time for co-counsel. Is there any questions I can address quickly?
I don't think so.
All right, thank you, Your Honors.
Good morning. May it please the court. My name is Richard Chambliss. I'm representing Michelle Holden and her law firm as appellees. The conversation that has gone on what's been labeled now as the pre-litigation malpractice is a little bit of a red herring in my view. First of all, with respect to the Holden parties, they weren't retained until June 1 at the earliest. Tonto Supply had filed the lawsuit in May, and so if there was any pre-litigation malpractice, it certainly isn't attributable to the Holden defendants.
But in your view, does it not apply that wouldn't the same principles apply if 1 month into the litigation it becomes apparent that it's not going to go well? Is there no obligation to tell the client you need to drop this?
Well, Your Honor, that would be litigation malpractice. It wouldn't be pre-litigation malpractice, and so I'm trying to draw the line there.
Right, but what rule, are you saying that would, there's no claim for failing to say wait? There can be no claim in a loser case for failing to say wait. Settle the case.
What I'm saying is the plaintiff's claim, the appellant's claim in this case, that they got me embroiled in disastrous litigation. If there's some, first of all, there's no factual basis for that. But secondly, if there was, it wouldn't apply to Michelle Holden.
Okay, but I think the argument is Ms. Holden failed to say wait. You got a bad case.
Well,
here.
that's litigation malpractice.
And so you're saying that that's impossible.
No, I'm not saying that's impossible. If the record supported it, it would be possible.
Right.
This record does not support that. There is no evidence, and I guess what I would point to in part is their amended complaint, which is a record at 44. And in the amended complaint, it talks, and counsel was trying to find the paragraphs, paragraph 26 of the amended complaint. On June 22, defendant Holden, on plaintiff's behalf, accepted service as summons a complaint. That defendant Holden filed her notice of appearance that same day. After settlement negotiations failed, litigation ensued.
So your point is, since there's no allegation that settlement would have worked out after your client.
There was no allegation made in the complaint. There is no factual basis to support that allegation if it was made. Mr. Zlackett does not give an opinion that says, well, if Ms. Holden or Ms. Armenta would have said X, it would have resulted in a settlement. There's absolutely no factual basis for that. Completely speculative. Further, when you look at the amended complaint and you look to the two counts that are asserted in the amended complaint, count 1, legal malpractice against Ms. Armenta, count 2, legal practice against Michelle Holden. The paragraph 78 and 79 of those, the claim against Ms. Holden, says, but for the negligent conduct, the MSJs would not have been granted.
Right. It's a different
79,
theory.
but for the negligent contract, they would have prevailed at trial.
Right.
There's no basis in
it's
the
different
record
from
for
the
that.
opinion.
But secondly, my point is, there is no pre-litigation claim that was asserted.
What relevance, if any, is the issue of whether Ms. Herren had a legal right to mine the minerals?
Well, I would consider that the sort of biggest Alice in Wonderland issue in the case. The motion for summary judgment on lost profits was filed, fully briefed, was argued. Trial court judge made a decision and said the $2.2 million in lost profits relating to the mining claim is gone because she has no mineral rights.
How was the mining claim lost in the litigation? That's what I don't understand.
The mining claim was not lost in litigation. It never existed.
Oh, okay, but I mean, how does the absence of a mining claim bear on the malpractice case?
Does it just go to the damages?
So,
the
yeah,
amount of
the
damages?
plaintiff's theory now, not the one that they filed their lawsuit on, the plaintiff's theory now is they just should have gotten better advice somewhere along the line that they didn't have any mining rights, and the failure to give that advice that they didn't have any mining rights is malpractice. No basis in the record
I
for
think
that.
we've heard that's not the claim now.
Well, his claim is twofold, because he has stood before the court and he said, look, I've got them both ways here. They either screwed up and didn't give good advice about the mining rights, or their malpractice resulted in the loss of the mining rights by the summary judgment motion that was granted. So he's trying to have it both ways. I think the trial court said in the motion for lost profits, I'm looking at the two deeds, and we have this, my difficulty with trying to figure this out is the label profit a prendere. And what I say is there's mineral rights. One is the right to the minerals, owning them themselves, and the other is the right to mine the minerals, that being the profit prendere. Easier for me to say right to mine the minerals.
But here's what I don't understand, though. Why is this relevant to the malpractice case? It seems to me that the bad part about, or the loss in the malpractice case is, boy, she figured out that she's going to have to pay some money to Tonto Supply, and she's going to have to find a new contractor to mine the sand for her. So she's not lost profits by losing that lawsuit. She can always go and get the profits by engaging with someone else.
I'm not sure I'm following, but I'll do my best with that. Herren's position at trial, before trial, after trial, and up on appeal was she owns, first of all, I own the mineral rights. Now
Right.
that's morphed into, I didn't really own the mineral rights. I own the right to mine the mineral rights. And I've lost the right to, so if I would have fired Tonto Supply and if I would have hired subcontractor ABC company, I would then have been able to go in and get my mineral rights under the underlying agreement.
Well, I would have been able to exercise my mineral rights.
Well, but what the trial court said was
In
Herren
what
has,
case?
excuse me?
In what case?
What the trial court said in the underlying action, the Tonto Supply, no, let me restate that. What the trial court said in this case, Judge Moreau says, she has no mineral rights. The 1953 deed from Santa Fe to Ford said, as in broad a language as possible, that all right, title, and interest in and to all minerals
I-
whatsoever.
I
Bear
get
with me
that,
one
but why
second.
did you raise that in this case? That's
Pardon
what
me?
Why did you file a motion for summary judgment on that question in this case?
I filed it because it was a $2.2 million claim that the plaintiff was asserting against my clients.
So that would just go to the amount of damages. There could be other damages if there's
To
causation.
answer the court's
still.
question, there are roughly two components of damages. The mining rights, 1.8 million to 2.2 million was their expert, and then another, under their version, $335,000 of additional attorney's fees paid, adverse judgment, loss of some property. When the court, Your Honor, when you're asking me why did I file the motion for summary judgment on lost profits, it's because I'd rather be litigating a $300,000 case
Absolutely.
than a $2.5 million
So the answer
case.
is because that was an element of the damages that,
That was a component of the
Raised.
damages asserted by the plaintiff.
If you prevail on causation, then it takes care of.
We prevailed on causation thereafter. The first motion was lost profits to narrow the damage, and the second motion was causation. I don't know if there's going to be a rebuttal on joint and several liability. I've addressed there's no pre-litigation malpractice with respect to Ms. Holden. The argument regarding joint and several liability basically says Rule 39 imposes civil liability on lawyers jointly and severally if it's a pro hac vici relationship. Rule 39 may have a disciplinary matter connect to it, but it's not civil. 122602 and 122506, we don't have any joint and several liability. My time is up. Thank you.
Thank you, counsel.
will be brief. I thank you for your patience, by the way. The malpractice can come across in three different ways here, maybe more, but pre-litigation, and then once you're into the lawsuit, time to say, stop the madness, let's get out of Dodge, and then handling the lawsuit properly. And we're focusing more on the pre-litigation, and once you get in, let me out. I haven't had a case where I've been accused of being a Trojan horse before. I don't think it applies. I'm not inside a wooden horse being dragged into the enemy citadel, so I don't think that works. And Alice in Wonderland, I haven't said anything that merits going down the rabbit hole that I can think of. As far as cases that support the proposition of non-litigation malpractice in this case, I set them out on pages 61 and 64 of the opening brief. They're the Tenon, the Toy, Commercial Union, Tuller, Best Choice, and Arizona Management Corporation cases. They all give support for the idea that you can have legal malpractice without being in litigation. You can have legal malpractice by giving bad, crummy advice, which is what these folks did. I hope the profit of prongray theory works. It's a great subject. I love it. Historically, it tingles my spine. But if there's no further questions, I will cede my remaining time to the court.
Thank you,
Thank you
counsel.
very much.
Thank you very much.
Appreciate the arguments presented here this morning, as well as the briefing provided to the court. We'll take this matter under advisement and issue a written decision in due course. With that, we adjourn.